we'll start a new subject under constitutional law of India, and that is constitutional remedies as provided under Article 32 and as relating to constitutional remedy. It was innovated by Chief Justice Marshall in the leading case Marbury versus Madison in 1803 in the United States of America Supreme Court, and to our disbelief that we found the very judicial review of constitution or constitutional remedy is not a part of United States America's Constitution. It was a judicial innovation by the Supreme Court of United States, and in India it is an important element of the Constitution and of Part 3 of the Fundamental Rights as provided under Article 32, and in relation to that we would like to discuss the very constitutional remedies in the form of judicial review as available under Article 32. So, to examine, analyze all these provisions, we have selected and made 14 different separate heads to discuss and analyze these available remedies. As for the first one, that is relating to scope of Article 32 or judicial review. And in that connection, we would like to discuss some important leading cases which would make one clarify exactly what is the scope, application, and jurisdiction or ambit of Article 32 in the form of either judicial review or constitutional review. So, we'll discuss the first important leading case, that is Kuriakkochi versus State of Kerala, and it was a case of 1977 where Supreme Court expressed that only fundamental rights falling within the category above can be enforced under Article 32, and all these fundamental rights which are falling under Part 3 of the Constitution. And the second important leading case in relating to this is that Indian Express newspaper Private Limited versus Union of India, and it was decided in the year 1986 by the Supreme Court, where it was pronounced as Supreme Court cannot determine an issue not involving fundamental rights. So it is exclusively has the jurisdiction of judicial review under Article 32, and which is only a fundamental right. And now we'll go to the third important leading case, that is People's Union for Civil Liberties versus Union of India, decided in 2004 by the Supreme Court, where it was pronounced that the Supreme Court cannot go into and examine the need of Prevention of Terrorism Act 2002 or POTA, it is a matter of policy. Once legislation is passed, the government has an obligation to exercise all available options to prevent terrorism within the bounds of the Constitution. And now we'll go to the fourth important leading case, that is Sri Siddhavali Steels Limited versus State of Uttar Pradesh. In 2011, Supreme Court expressed that the petition under Article 32 could not be entertained where the petitioners were not differentially treated, nor the tariff was sought to be recovered in any illegal or arbitrary manner. And now we'll go to the next important leading case, that is Rajasthan State Road Transport Corporation versus Santosh. In 2013, Supreme Court expressed that it is permissible for court to exercise of power under Article 32 of the Constitution to issue directions if the law does not provide a solution of problems as an interim measures. And now we'll go to another important leading case which justifies the very scope of judicial review under Article 32, and that is Alagpuram or Maharaja versus Tamil Nadu Legislative Assembly, and it was decided in 2016 by the Supreme Court, where it was expressed the scope of judicial review in matters of action taken against members of legislative bodies is limited, but it is well settled principle that non-compliance with the principles of natural justice is one of the limited grounds on which judicial review can be undertaken against the internal proceedings of legislative bodies in appropriate cases. And now we'll go to the second head that we have made as it is a fundamental right. So, Article 32 of Part 3 dealing with constitutional remedies or judicial review is itself a fundamental right, and in regards to that, we will discuss the leading case. Assam Public Works versus Union of India, decided in 2015 by the Supreme Court, where it was held that Article 32 of the Constitution guarantees the right to move the Supreme Court for the enforcement of all or any of the fundamental rights conferred by Part 3 of the Constitution. This article is therefore itself a fundamental right, as it was pronounced by our Apex Court in this particularly important leading case, Assam Public Works versus Union of India in 2015. And now we will go to the third head that we have chosen, that is basic feature of the Constitution. So, regarding that, we will discuss two important leading cases. One is Kyoto Uluwan versus Jachilu in 1993. Supreme Court expressed that judicial review under Article 32 and 226 is a basic feature of the Constitution beyond the pale of amendability. And in regards to this, we will discuss another important leading case, that is Namit Sharma versus Union of India, decided in 2013 by Supreme Court, where it was expressed that the independence of judiciary is of fundamental constitutional value in the structure of our Constitution and is a basic feature of the Constitution as it was declared in this very important leading case, Namit Sharma versus Union of India in 2013 by the Supreme Court. And now we'll go to the fourth selected head that we have chosen, that is the doctrine of latches, where you will discuss two important leading cases. One is Tilok Chand versus Munshi in 1970. Supreme Court expressed that latches or unreasonable delay in instituting writ petition may bar the remedy, as it was declared in this particular important leading case, Trilok Chand versus Munshi in 1970. And now we'll go to the second important leading case, and that is Dheri Rothas Light Railway Company Limited versus District Board Bhojpur in 1993. Supreme Court expressed that refusal for delay has been described as a rule of practice. And now we'll discuss another important leading case, and that is Bhaskar versus State of Andhra Pradesh, and it was also decided in 1993 by the Supreme Court, where regarding latches it was pronounced that unexplained delay may entail refusal to issue a writ, as it was pronounced in this important leading case, Bhaskar versus State of Andhra Pradesh in 1993 by the Supreme Court. And the fourth important leading case relating to the very doctrine of latches, as it was pronounced under constitutional remedy under Article 32, is Narmada Bachao Andalan versus Union of India in 2016. Supreme Court expressed that where the government, in view of the policy decision to construct dams, Sardar Sarovar project on river Narmada, had granted the environment clearance after conducting studies, the petition opposing the construction of dam filed by way of public interest litigation after commencement of execution of project would be barred by the doctrine of latches, as it was declared in this important leading case, Narmada Bachao Andalan versus Union of India in 2000 by the Supreme Court in regarding to explain exactly the jurisdiction of Supreme Court on the doctrine of latches while dis- deciding petitions filed under Article 32 for constitutional remedies or judicial review. And now we'll go to the fifth head we have selected, and that is res judicata. And in that connection, we'll discuss two important leading cases. One is rural litigation and entitlement Kendra versus State of Uttar Pradesh in 1989, the Supreme Court expressed that if the petition is dismissed in live without passing a speaking order, then such dismissal cannot be treated as creating a ban on res judicata. It is true that prima facie dismissal or even without passing a speaking order in that we have may strongly suggest that the court took the view that there was no substance in the petition at all. But in the absence of speaking order, it would not be easy to decide what factors weighed in the mind of the court, and that makes it difficult and unsafe to hold that such a summary dismissal is a dismissal on merits and as such constitutes a ban of res judicata against a similar petition filed under Article 32 if the petition is dismissed as withdrawn. It cannot be banned to a subsequent petition under Article 32 because it's in such a case there has been no decision on the merits of the court. So also, res judicata applies in writ petitions generally, though not in public interest litigation, as it was decided in this leading case, rural litigation and entitlement Kendra versus State of Uttar Pradesh in 1989 by the Supreme Court. And now we will go to another important leading case relating to res judicata is Baby Divasi Chudli versus Union of India in 2013. Supreme Court declared that the doctrine of res judicata or the principles of finality of judgment cannot be allowed to whittle down or override the express constitutional mandate to the Supreme Court as enshrined in Article 32 of the Constitution, as it was declared in this very important leading case regarding the application of the doctrine of res judicata. And now we'll go to one of the important, outstanding development made in India in regards to the very doctrine of fairness patriae, which itself is considered as that when the entire nation would be considered as guardian over all the citizens and individuals of the state, and it would take all responsibility as the guardian of the nation. So, in that case, we will discuss the very important leading case in the history of Supreme Court, and that is otherwise known as the Bhopal leak, gas leak disaster, which occurred in 1984. And in regards to that, we discuss the important leading case, Charan Lal Sahu versus Union of India in 1909. The Supreme Court expressed that any person complaining of infraction of any fundamental right guaranteed by the Constitution is at liberty. So, to explain this very concept as it was expressed, the Supreme Court in this Bhopal gas disaster revisioning of Claims Act uphold the validity of the Act of 1985. This judgment discusses the doctrine of fairness patriae. It also takes note of the fact that the legislation in question related to actionable wrong under the seventh schedule concurrent list entry 8. It is also contains a suggestion in para 129 to lay down certain norms and standards in regard to the industries dealing with materials which are of dangerous potentialities in the judgment of Mr. Justice Ranganath Mishra. There is a suggestion that either the Fatal Accidents Act 1855 should be amended or fresh legislation enacted to deal with victims of mass disaster. Inter alia, the suggested legislation should deal with the following matters as it was expressed by the then Chief Justice of India, Justice Ranganath Mishra, that fixed minimum compensation on no fault basis pending filing adjudication of the case, and the second is creation of a special forum with specific power to grant interim relief in appropriate cases, and the third one, evaluation of a procedure to be followed by such special forum which will be conducive to the determination of the claims and avoid high degree of formalism in proceedings, and the fourth one, a provision requiring industries and concerns engaged in hazardous activities to take out compulsory insurance against third party risks. So the court did not uphold the argument that the act was against Article 14 of the Constitution as it was declared by the then Chief Justice of India, Justice Ranganath Mishra. In this particular important leading case, Charan Lal Sahu versus Union of India in 1990 Supreme Court, and it is otherwise known as the Bhopal gas disaster case. And now we'll go to another important aspect, that is locus standi, which we select under the head as regarding locus standi. We'll discuss one is T.N. Rugamani versus C. Achyuta Menon in 1991 Supreme Court expressed that in this particular leading case that locus standi to file a particular petition under Article 32 depends on the facts as they existed at the time when the petition was filed. And in the another leading case, that is Narayanjit Singh versus Union of India in 2001 Supreme Court expressed or pronounced that any person complaining of inaction of any fundamental right guaranteed by the Constitution is at liberty to move to the Supreme Court. But the rights that could be invoked under Article 32 must ordinarily be the rights of the person who complains of the infraction of such rights and approaches the court for relief, and the proper subject for investigation would, however, be as to the nature of the rights that is stated to have been infringed, as it was pronounced by the Apex Court in this important reading case, Narendrajit Singh versus Union of India in 2001 by the Supreme Court. And in our next upcoming video, we'll discuss other selected heads that we have made, and the next one that we would like to discuss in the upcoming video is relating to public interest litigation and judicial review, and that we would like to discuss in our upcoming video, which would fall under head 8, and almost there are 14 heads we have made to examine and analyze the very decisions of the Apex Court relating to very scope and jurisdiction its ambit, relating to constitutional remedies or judicial review.